Hello, everyone. My name's Dr. Steve James. I'm a consultant in critical care. And as you may know, I've been asking some questions recently about the vaccine mandate. I'm very pleased that this evening I've got the opportunity to speak to Stephen Jackson. Stephen is a solicitor with the team Law or Fiction, and he's been working on this topic as a solicitor since the beginning of COVID. Hello, Stephen.
Hi there, Steve. How are you doing?
Yeah, very good. Thanks for coming this evening. I've got some questions that have been sent in, and we're just going to go through those, and hopefully we'll get everything we need tonight. So first of all, do staff have to attend any meeting around their vaccination status, or do they need to reply to questions about their vaccination status?
They're not obliged to say what the vaccination status is. That remains a matter of personal record. It's a question of cooperation. People are uncomfortable about refusing things, but it's an uncomfortable situation. So the answer is, if you're asked to attend a meeting, you can say no, and I think they should say no. If there's an insistence on attending, then insist on being accompanied by someone, preferably your union representative.
Okay, so then that would mean that there's no legal requirement for them to inform their employer about their vaccination status, and it wouldn't matter whether they've had no vaccines or one vaccine or however many vaccines.
Well, that's correct, technically speaking. Until the 1st of April, there's no absolute need for the employer to know. Of course, the employee wants to plan, but so does the employee, and the employee wants to protect their personal information. They can politely say, well, I'm thinking about it, but I'd rather not disclose, and I'll let you know in due course.
Does the mandate apply to all staff or just those who are patient-facing, or do we know where the distinction is going to be?
Well, that's one of the difficult things, is where the distinction is. Essentially, it's face-to-face, but many employers' hospitals are adopting a very broad brush approach to this, and people who would think they might be excused from this, they don't have face-to-face contact normally, are finding themselves subject to letters or threats that they're going to be out of a job on 1st of April. So I think in all events, it doesn't really matter which camp you're in. Jobs are at risk for everyone.
So does it kind of matter on how the trust is interpreting in the law then, and that's what each employee is going to face?
Well, different trusts, different employers will be interpreting the law in different ways. I think the important point is simply for employees to hold the line for the time being. That's a message which Together is putting out, and it's the right one. What's going on here, let's be clear about it, is a push from the government through the trusts and their directors to get people to accept the vaccination, and they'll do it one by one, drip by drip, just trying to get more and more people to accept the vaccination under the pressure and threat of dismissal.
Can trusts then legally send dismissal letters after February the 3rd if they don't know, or if they do know your vaccination status?
They can send dismissal letters. A few of them, foolishly perhaps, might. And those dismissal letters might be effective. But does that mean they are lawful? That's a slightly different matter. They might be effective, so the employee receiving them might see that they have a dismissal date of 31st of March, for example. Before that time, there is every possibility, if people stand together, that Sajid Javid will pause the regulations or withdraw them completely. And when that happens, the dismissal notices, well, the employer will probably write and say, we'll withdraw those. And we might think, well, that's fine. Everyone's happy. It was a nasty moment while it was there, but we can all move back to normal now. Well, it's not quite like that, because there's still been a pretty nasty phase when many will feel they've been discriminated against, have suffered a fair amount of injuries to the feelings, indeed injury, mental illness and physical illness as a result of what's happened. And there may still be some significant numbers of claims being made for what has happened. Now, it might have been that employers could have relied upon the courts in due course as to whether or not the regulations were discriminatory. But if the regulations are pulled, that defense, which might become available to the courts, is probably not going to become available. And then the trusts and the employers are left high and dry by the government. And in terms of defending, to say their actions were justified, discrimination was justified, they won't have the evidence or support to do that. So they're in a lot of difficulty.
So how much notice does a trust need to give an employee, and does it vary according to length of service, and is that going to apply in this situation?
An interesting point you raised, Steve, is that it's likely that the notices will end at 31st of March and not before very often, or they might extend the further 12 weeks. But what is interesting is the fact there should have been consultation about these things. What seems to have been missing throughout these last weeks and months is proper collective consultation through employee representatives and through the unions as to what is going on. The fact that regulations might mean employing someone after the 1st of April is difficult. That doesn't absolve the employer from consulting in relation to the numerous and many dismissals which will happen at about that date. So there are collective consultation obligations which are being ignored, and the costs of that are likely to be very significant because it could be as much as 13 weeks per employee affected. These are significant complaints which lie in waiting for employers as soon as the dust settles.
And what do you think that an individual should do if they think that their trust is acting illegally?
At the moment, one of the first things which employees should be doing is writing to their trust directors and to managers and asking that the emails and documents passing between them in relation to the plans should be held and not destroyed, because there is prospective litigation here. And what it will come out in the course of disclosure in litigation are the communications which might show what they're really thinking. There's a real suspicion at the moment that behind the scenes, government and trusts are together agreeing, well, let's just keep pushing, but we know we're going to pause these regulations, but let's get as many vaccinated as we can. Let's see how far we can go. That should all come out in disclosure, and the individuals on the trust boards really ought to be quite concerned about that. They're telling the workers one thing whilst doing another. Is that what's happening? That could be rather important when it comes to the consultation obligations, which I mentioned.
Can staff be dismissed in their absence, for example, if they're off on long-term sick leave, maternity leave, or on sabbatical?
There'll be many employees who are off on sick leave at the moment because of the strain of all of this. There are many who will be going off very shortly, I suspect. It becomes much more difficult for the employer to deal fairly with them if they are on sick leave and unable to be represented properly in the course of a dismissal process. So an employee who goes ahead in dismissal in the absence of being able to have that proper discussion and consultation with the worker may find themselves committing an unfair dismissal in due course, and also one which may well be discriminatory. So lots of potholes in the road for employees who proceed at this time. The important thing is for employees to hold the line. Don't give up. It is the employer to make the move. It's for the employer to make mistakes, and mistakes they are making.
So from what you've been saying, there's certainly a chance that some people will be able to claim unfair dismissal if this process goes ahead.
There will be many, many claims of unfair dismissal. Quite how they will resolve in the long term, we don't know. It's too early. These are still novel circumstances which we're facing. It rather depends perhaps on the judicial reviews which are going to be going ahead of these regulations and when they are pulled, and if employers move ahead with their dismissals before the 1st of April. So it's a wide range of circumstances, but there will be unfair dismissals amongst this lot, most certainly.
So if you are dismissed, does that jeopardise your NHS pension rights? And what about if you've got outstanding leave that's owed at that time?
When there's a dismissal, it will take effect in the same way as ordinary dismissals even before the pandemic started. So the same principles will apply, and people will be able to claim for their losses. But it's the usual unfair dismissal and discrimination principles which apply.
So just one sort of final thing, is it okay then if employees respond to their trust and say that my vaccination status is a private matter, and until the 1st of April, no law enables you to act upon not knowing my vaccination status?
That's certainly one view they might take. It's a question of always still being polite and reasonably cooperative, but how cooperative you have to be is another matter. You're not required to breach your right to privacy in respect of your medical records, and that remains a fundamental aspect of this.
Many people have spoken to me and said that they're being hassled or bullied by their line managers. What do staff do in those circumstances?
If they're concerned about bullying, there's no question they should raise a grievance. They can do that informally or directly informally if it's serious enough. Use a grievance procedure straight away and record it and make a stand. Do not put up with it. No one has to put up with bullying in the workplace.
Stephen, what happens if letters of dismissal have gone out after February the 3rd and then the government changes its mind? What position are trusts in and those employees who've had those dismissal letters?
I think the expectation of everyone will be, including the trust issuing these dismissal notices, is that they will simply withdraw them and reinstate the employment of everyone who's had the notice. That's the expectation. If the regulations are paused or removed completely, it might be that we don't get a resolution in the courts, which would have happened otherwise through judicial review. It's possible that judicial review, the legal challenge, might go ahead anyway, but let's assume it doesn't for the moment. If we don't have a resolution in the courts as to whether or not the regulations are discriminatory or justified in any way, then it remains open for the employees who've suffered some considerable distress. It could be that there are many discrimination claims, and those will be raised not just against the employers, but they'll go against the individuals who've been responsible for the management decisions.
Stephen, from your interpretation of the law, what do you think trusts should be doing over the next few weeks in regard to this legislation, if they want to protect themselves from future claims?
The best thing for trusts and those who are running them on their boards is to bring an end to this straight away. Whatever is going on behind the scenes, the correspondence, the data they have, that's going to come out in the wash. It's not going to be hidden forever, and individuals will be shown to have been involved. The best thing for everyone is just to bring this to an end and do it now. It needs completely reviewing.
Thank you very much for answering those questions, Stephen. I'm sure we'll continue this relationship and look forward to further work with you.
I'll be seeing you soon, Steve.
We will indeed. Thanks very much.